Hi, I'm Noah Weisberg.
And I'm Rebecca Rauws.
Welcome to Holland Estates. You are listening to episode number 538. How are you, Rebecca?
Good. How are you, Noah?
I'm doing well, thanks. Today's a big day. We're going to be discussing a very important decision arising out of the Supreme Court of Canada. It's the decision in Cowper-Smith and Morgan. For our viewers out there, they can find it on the Supreme Court of Canada website as well as on Canley, and the citation is 2017 SCC 61. So I say it's a big day because rarely do we in the Estates Bar receive decisions from the Supreme Court of Canada which has a big impact on our day-to-day practice.
Right.
And today is one of those days, so happy to be discussing this decision with you.
Yes, I am as well.
So why don't, Rebecca, we start by just briefly setting out what the facts of the case are.
Sure.
And our viewers and listeners can keep in mind that this is a decision that revolves around proprietary estoppel and how the courts have, to a certain extent, increased the scope of when it is applicable regarding ownership of real property.
Right. Okay, so I'll go through the facts quickly. So there were three siblings involved in this case. There was Gloria, Max, and Nathan. Seems like there were kind of some sibling issues going on between Gloria and the other two. Their mother died in 2011, and prior to that was when all of these facts kind of came to be that led to this claim. The mother's will, her last will, provided that her estate was to be divided equally between her three children. However, about a year prior, she had executed a declaration of trust which provided that the house and some other stuff, but I think the house is the main issue that we're talking about in this case, was to be held by Gloria as bare trustee for the benefit of Mom, and that Gloria was to be entitled to the assets absolutely.
Right. So just to summarize that, mother and father have three children. They both indicate that they will leave their estate to the kids equally. Husband passes away.
Yes.
Mother survives. There's a breakdown in the relationship amongst all the kids. The kids still believe that they're going to be entitled to a 1/3 interest. One of the children moves back home, takes care of Mom while she's elderly, and the child does so on the condition that when Mom passes away, he'll be entitled to purchase Gloria, the daughter's 1/3 interest in the real property.
That's right. Yeah, when he was making the decision about whether to move back home or not, she had told him, if you do, then I'll let you buy my 1/3 interest.
Right.
And then she later obviously resiled on that promise, which
Right.
led to what we're talking about today.
Right. At trial, the trial judge, this is, I believe, out of British Columbia,
Yep.
applies proprietary estoppel, and the judge basically holds that the son who moved back home to care for his mom, gave up his occupation, gave up his life abroad, and essentially was owing for all the efforts that he did on behalf of Mom, and that it was fair for him to be able to purchase his sister's interest in the real property.
Right.
And the judge does apply the three-part test of proprietary estoppel. And the judge finds that the son should have been entitled to receive property based on his sister's promise.
Right. So the brothers were successful at trial, and then the sister appealed to the Court of Appeal. The Court of Appeal overturned the decision on the proprietary estoppel point, finding that because Gloria didn't actually own the interest in the house at the time that the promise was made, proprietary estoppel couldn't have arisen.
Right. So basically, just so I understand that point, Rebecca, is the promise was made by the daughter, Gloria, while Mom was still alive, and while her estate obviously remained with Mom when there was no such estate.
Right.
So the Court of Appeal says that it was unreasonable for the child who gave up his life to care for Mom to receive the promise because daughter didn't have the land, and how could she have passed it over?
Right.
Promised to give it to him later on.
Yeah, she didn't have the interest to give away, I guess.
Right.
Simply,
right.
Yeah.
So trial decision says uphold proprietary estoppel. Court of Appeal says sorry, no dice. What does the Supreme Court of Canada say?
Supreme Court went back to the trial judge's decision, and they found that proprietary estoppel had been made out in this case, but they specifically considered the reason that the Court of Appeal found for denying the proprietary estoppel being that she didn't own the interest in the house at the time.
Right.
And as you mentioned, whether it was reasonable for the brother to have relied on her promise was a big factor. And when the court talks about that, they mentioned that everyone knew what the estate planning setup was. It had been known between the kids that it was to be split 3 ways, and this was how it had been for some time. So it was reasonable for the brother to have taken that assurance from Gloria that he could purchase it, because for all he knew, she would be one day entitled to that interest.
Right, exactly. And I think the key, we were both flipping to the page in the decision, is that, the equitable interest doesn't attach once the promise is made by Gloria.
Mm-hmm.
It attaches once Gloria receives the interest in the property. And
Right.
to a certain extent, it can lay dormant for a little while until the property is received
Mm-hmm.
by the person who made the promise. And for us, that's huge.
Mm-hmm.
We're essentially acknowledging that proprietary estoppel can, to a certain extent, lay dormant
Mm-hmm.
and can attach to promises that don't come into fruition until a later date.
Right.
Before we get into the takeaway, why don't we just briefly look at what the 2 other concurring decisions said.
Right. So there was Justice Brown and Justice Cote both agreed on the main point of the decision, but they disagreed on some smaller points. Justice Brown disagreed with the appropriate remedy. So briefly, the remedy that the majority gave to the brother was that he would be able to purchase Gloria's interest at the value of the property as of shortly after Mom's death.
Which was the day in which Gloria receives the property, right?
She would, if this hadn't happened the day, he could have expected to be able to purchase it.
Shortly after Mom's death.
Yeah.
Right. And importantly, they all concurred with Justice McLaughlin's reasons.
Mm-hmm.
They just had different ideas to how damages should be assessed, right? So ultimately, though, McLaughlin's decision stands.
Mm-hmm.
Proprietary estoppel can lay dormant, as we discussed earlier on.
Mm-hmm.
And I think the takeaway is huge. I mean, not only is it a great illustration of parents taking the time to discuss their estate plan with the children, but even more so that parents, that solicitors should talk to parents and should talk to siblings about, were there any promises that arose with respect to the division of estate, and do those need to be addressed in any will?
Mm-hmm.
So definitely solicitors, they want to include that in their checklist when they meet with testators as to any promises that arise or could arise later on.
Right.
Anyways, great decision. Supreme Court of Canada, always a fun topic to discuss. But I do believe that does conclude our podcast. Until next time, we want to thank you for listening. I'm Noah Weisberg.
I'm Rebecca Rauws.
Should you have any questions, please email us at webmaster@hollandholland.com or leave a comment on our blog. Thank you.
Thanks.